Welcome back to the lecture Introduction to Law. In this last unit of the lecture, we will talk about arbitration and mediation. For some, the idea of having to conduct a lawsuit is very unpleasant. This problem is not only experienced by private individuals, but also by entrepreneurs and industrial groups. The main concern is that the lawsuit could be lost. If the case is lost, there is the danger of having to bear the costs. This is because, in principle, the losing party must bear not only its own legal fees and court costs, but also the costs of the opposing party, the attorney's fees. In addition, proceedings in state court system often take a very long time. This raises the question of whether there are more cost-effective and faster alternatives to litigation. Dispute resolution therefore plays an important role in legal practice. Broadly speaking, a distinction is made between arbitration and mediation. Arbitration and litigation are both formal methods of settling business disputes. They differ in who hears the dispute, how the process works, and whether the decision can be appealed. Arbitration involves two parties in a dispute who agree to work with a neutral third party in an attempt to resolve the dispute. Arbitration is used in place of civil litigation involving two parties. Litigation, on the other hand, is a process that involves determining issues through a court with a judge or a jury. Arbitration is a process before a non-governmental arbitration court, a kind of private civil court. The arbitration procedure is regulated in sections 1025 following of the German Code of Civil Procedure, Zivilprozessordnung, or abbreviated ZPO. It allows the parties to settle a legal dispute before a private arbitration court by means of a so-called arbitration agreement, thus removing it from the jurisdiction of the state courts. This excludes recourse to the state civil courts. The legal dispute between the arbitration claimant and the arbitration respondent is determined by an arbitration award made by one or more arbitrators. The arbitral award shall take the place of a judgment of a state court. It is binding on the parties and may be declared enforceable. Arbitration proceedings, whose place of proceedings is in Germany, shall be governed by the 10th book of the Code of Civil Procedure, unless the parties make provisions for their arbitration proceedings which deviate therefrom. If reference is made to the rules of procedure of an arbitration institution, these shall be deemed to have been agreed. The arbitration agreement may then dispense with the regulation of details of the arbitration proceedings. Arbitration procedures with their own rules of procedure are offered by several institutions. For example, the International Chamber of Commerce, ICC, or the German Arbitration Institute, DIS. Mandatory procedural guarantees are the right to be heard and the equal treatment of the parties, regulated in section 1042 of the ZPO. In contrast to state court proceedings, arbitration proceedings normally have only one instance. However, upon application, a higher regional court may set aside the arbitral award in an event of cross-procedural violations. In principle, the higher regional court, or short OLG, does not review the substantive correctness of the arbitral award. Institutionalized arbitration proceedings may additionally provide for a supreme arbitral tribunal to review the arbitral award for cross-procedural violations and, if necessary, set it aside. Another difference between state court proceedings and arbitration proceedings is that in state court proceedings, the principle of publicity applies to the hearing and the pronouncement of the decision, whereas arbitration proceedings are in principle, that means unless otherwise agreed, not public. Confidentiality must, however, also be agreed separately in arbitration proceedings between the parties. The non-public nature of the proceedings is sometimes regarded as problematic from the point of view of separations of powers in relation to arbitration proceedings in which sovereigns are involved. As a rule, the arbitration court is composed of 3 arbitrators. The arbitral tribunal must be independent and neutral. The arbitral award shall have the effect of a final judgment for the parties. Enforcement of the arbitral award is only possible after a declaration of enforceability by a state court. In certain cases, the arbitral award may be set aside, for example, in case of lack of impartiality of the expert engaged. This possibility of autonomous conflict resolution through binding arbitration by a third party is used primarily by companies in international, commercial and economic disputes. A major advantage of private adjudication is above all that arbitral awards are recognized and declared enforceable worldwide, whereas a national judgment is not recognized in all states. Institutional arbitration organizations are therefore preferred as arbitration tribunals. The advantages of arbitrations are the greater flexibility of the proceedings, the shorter duration of the proceedings, the lower costs in case of high amounts in dispute, the non-public nature and thus confidentiality of the proceedings, the special expertise of the arbitrators in technical or legal matters, the free choice of the place of arbitration and the language of the proceedings, the free choice of law, and the international enforceability of the arbitral award. The statute of limitations for the claim is suspended at the start of the arbitration proceedings. The prerequisite for arbitration proceedings is an arbitration agreement under private law between the parties. Unilateral agreements, for example in a will, a testament, are not sufficient. The arbitration agreement must be voluntary. The formal requirements are listed in section 1031 of the ZPO. The subject of an arbitration agreement can be any claim under property law. Arbitration agreements in rental matters, for example, are excluded. If an arbitration agreement exists and an action is nevertheless brought before a state court, the action must be dismissed as inadmissible if the defendant objects to this in good time. As an example, let's take a look at the standard ICC arbitration clause, the clause of the International Chamber of Commerce. All disputes arising out of or in connection with the present contract shall be finally settled under the rules of arbitration of the International Chamber of Commerce by one or more arbitrators appointed in accordance with the said rules. This is a standard clause for arbitration which can be changed by the parties. On its website, the ICC explains, parties are free to adapt the clause to their particular circumstances. For instance, they may wish to stipulate the number of arbitrators given that the ICC arbitration rules contain a presumption in favor of a sole arbitrator. Also, it may be desirable for them to stipulate the place and language of the arbitration and the law applicable to the merits. The ICC arbitration rules do not limit the parties' free choice of the place and language of the arbitration or the law governing the contract. When adapting this clause, care must be taken to avoid any risk of ambiguity. Unclear wording in the clause will cause uncertainty and delay and can hinder or even compromise the dispute resolution process. Parties should also take account of any factors that may affect the enforceability of the clause under applicable law. These include any mandatory requirements that may exist at the place of arbitration and the expected place or places of enforcement. These are some additional notes from the ICC to the standard arbitration clause. Let's talk about mediation. Mediation originates from the US American legal practice. Since the 1990s, this extrajudicial dispute resolution model has found its way into German and European legal culture. In mediation, the parties engage an independent and neutral mediator who essentially acts as a facilitator. The aim for the parties to reach a mutual amicable agreement by working out their interests. The mediator has no coercive powers. He cannot dictate solutions to the parties or decide a dispute in a binding manner. The mediator therefore has no judicial function. The conflict resolution instrument of mediation is recommended above all in disputes with a particular personal connection, such as family law disputes, but also for neighborhood conflicts, tenancy and real estate disputes. In addition, there is also business mediation. That means conflict resolution between companies. Mediation in Germany is regulated by the Mediation Act. There you will find legal regulations for extrajudicial and judicial mediation. The aim of the Act is to change the culture of conflict in Germany and to offer an alternative to dispute. The Mediation Act first describes in more detail the tasks, powers, and training paths of the mediator. Emphasis is placed on the voluntary nature and confidentiality, and the mediator's duty of neutrality. Since mediation can be practiced by various professionals, the Mediation Act provides for the introduction of a certified mediator to protect the parties. These must fulfill various requirements in order to receive the protected title of a mediator. By entering into mediation, the parties do not suffer any disadvantages under the statutes of limitation law. If the parties reach an agreement before the mediator, a corresponding contractual final agreement is reached. That means an out-of-court settlement within the meaning of Section 779 BGB. This agreement is not enforceable. This is a major disadvantage of mediation. If the parties forgo mediation or other out-of-court conflict resolution methods and immediately seek litigation, the Mediation Act opens up the possibility for the court to once again attempt an amicable settlement. On this sheet you can find an example for a mediation clause here recommended by the ICC. On the website of the ICC it has different forms of mediation clauses. Here's the one with the option to use the ICC mediation rules. The rule states, the parties may at any time without prejudice to any other proceedings seek to settle any dispute arising out of or in connection with the present contract in accordance with the ICC mediation rules. On the website you can find explaining notes for this. By including this clause, the parties acknowledge that proceedings under the ICC mediation rules are available to them at any time. This clause does not commit the parties to do anything, but the presence of the clause is designed to remind them of the possibility of using mediation or some other settlement procedure at any time. In addition, it can provide a basis for one party to propose mediation to the other party. One or more parties may also ask the ICC International Centre for Alternative Dispute Resolution for its assistance in this process. At last, I will show you a mediation clause which is also an arbitration clause. The ICC Mediation Arbitration clause with the obligation to refer dispute to the ICC mediation rules, followed by arbitration if required. In the event of any dispute arising out of or in connection with the present contract, the parties shall first refer the dispute to proceedings under the ICC mediation rules. If the dispute has not been settled pursuant to the said rules within maybe 45 days, following the filing of a request for mediation or within such other period as the parties may agree in writing, such dispute shall thereafter be finally settled under the rules of arbitration in the International Chamber of Commerce by one or more arbitrators appointed in accordance with the said rules of arbitration. So arbitration is the stronger form of conflict solution. An arbitrator or an arbitration court decides the case. Mediation is a way to find a common ground without such authoritative ruling. The mediation and arbitration clauses come into effect between the parties only when they are agreed upon, especially by implementing them in the contract, for example in the company contract, the statute of the corporation. That's all for this unit. I hope you have enjoyed it.